leave, my lord, to move one urgent, my lord, public interest litigation, my lord, regarding,
File it. No urgency.
my lord,
With your lordship's leave, may I mention
Inclusion,
my
inclusion, upgradation, etc. next week. Any leave to file without certificate copy granted. Yes, sir. First,
My lord,
we'll pronounce the judgment, Patak. First, we'll pronounce the judgment.
my lord, I'm sorry, my
Mention one matter, my lord, to appear as a to be mentioned because your lordship was pleased to deliver a judgment on 31st July. There's a typographical error, my lord.
Yes, to be mentioned.
my lord, I'm sorry. My lord, if your lordships kindly permit me, my lord, to seek your lordship's leave in this matter, my lord, to move it unlisted. My lord, the issue is very sensitive, my lord. It relates to the vandalism that have been carried out yesterday
Wait,
in the
sir,
wee
you wait,
hour.
sir. There is a supplementary list. You wait. Yes, please call for that.
Item number
I'm here. Thank you. My name is Dr. Kunal Saha, my lord. I have come here in an excruciatingly urgent situation because poor patients are dying today.
Please wait. The matter will be called. Then you can.
My matter is not here. I'm here.
You are here. You are here, doctor. We will hear you. There's a supplementary list. 6 matters are
I
listed.
have not filed it.
You have not filed it.
No,
You please
Hello.
be here.
it's because I be here today. I'm going to file it today. But the doctor's right. Now, this death happened.
We once again say we will hear you when the matter is called. We have got 2 judgments to deliver. Please wait. Please call.
নমস্কার স্যার, আমি একটা কথা বলতে চাই। আমি পিটিশনার ইন পার্সন 28,142/2013 একটা মামলা ছিল।
I don't understand.
স্যার বাংলা একটু বলবার ব্যবস্থা
I don't understand. Don't mention elsewhere. Please call, sir.
Item number 1. Lordship, I am for the appeal. Lordship, I am for the appeal.
But I beg to appear for the petitioner. I am the petitioner in person. Item number 3.
Bakshi, this is a judgment being delivered. Please
Yes.
wait.
Yes.
For all the reasons as aforesaid, this court holds that the learned single judge was right in rejecting the prayer of the appellant for restoration of possession. Accordingly, the appeal and the connected application stands dismissed. There shall be, however, no order as to costs. The appellants are left free to approach the proper forum for appropriate reliefs in accordance with law.
Lordship.
Great. Judgment. For judgment is the original site. Item number 1.
Change করতে হবে।
Item number 1, original site for judgment.
In the result, it is held that the seizure by the preventive department of the customs is valid and the seizure is not vitiated for the reasons contended by the writ petitioner. And consequently, the order passed in the writ petition is set aside and the appeal is allowed. The customs department are directed to proceed with the investigation and take the matter to the logical end in accordance with the law.
Matters from the supplementary list. Item number 1 to 6.
Lord, with your lordship's kind leave, my lord,
I am the petitioner in person.
appearing virtually, my lord, on behalf of the petitioner in the second writ application, my lord.
But I am for the I am the petitioner in person. Item number 3.
Mr. Banerjee, the reason we listed this was from yesterday morning, several emails have been addressed to me reporting about the vandalism which has taken place in the hospital premises.
Yes.
And there was also a prayer saying that we need to file an application, etc. Therefore, we thought it fit we list the matter under the supplementary list under the caption to be mentioned. Now, what has happened?
As far as the vandalism is concerned, my lord, I without knowing why this matter was listed, I just took some arbit instructions from the authorities, my lord. Without, as far as what steps we have taken, my lord, from the vandalism, my lord, there was suddenly a mob of about 7,000 people.
7,000.
7,000 people. gathered over there. It was a demonstration was sought permission, but till for up to that period, whatever 200, 300, 400 people were there. But on that day, it swelled up to that big a number. And they carried out a huge, if your lordship so desires, I have videos with me, how they sort of broke open the barricades, moved the barricades, police trying to resist them, everything. Tear gas shells were fired to bring them into under control. 15 police personnel were injured. The Deputy Commissioner of Police was seriously injured. Police vehicles were also damaged. Not only that, my lord, the emergency was ransacked. But however, one good thing is the place of occurrence upstairs, which is on the floor, that is untouched, totally protected.
But one thing, normally even if 100 people gather, there is always an intelligence wing with the police. Intelligence wing with the police. In fact, we came across the same issue during Hanuman Jayanti. Because people, threw bricks from the 3rd floor. So therefore, the court commented on saying that unless it was a pre-plan, the bricks could not have been lifted to the 3rd floor, and there should have been movement of vehicles. And there was a serious failure on the intelligence of the state police. If 7,000 people are together, it is very hard to believe that the state police intelligence did not know about
there was supposed to be a demonstration outside, but
why did you grant permission?
Outside, no permission is taken. They just give intimations. No one takes permission.
For all and sundry reasons, you pass a 144 order. When there is so much of commotion is going on, the doctors are on strike, there are demonstrations, you should have cordoned off the entire area.
This was the demonstration which has been conducted, but your lordship knows that evening, or rather that morning, there was a movement, that there was a movement at the night. At every place in over Calcutta.
No, if suppose 7,000 people have to come, they can't come walking. They should have been brought by buses or trucks.
There were streams of people
Exactly.
Various places. There are various processions marching in. But that was supposed to be peaceful.
Failure of state missionaries.
Absolutely.
What happened, that day, they were ready for 500 to 700 people, which was
that sort of force was present over there.
Every day there was 12.
And the force couldn't protect their own men. You say that the policemen were injured.
Policemen are also injured. That is why.
Sorry, state of affairs. And how do you think these doctors will be in a position to work fearlessly?
Well, now it is completely under control, and
we have now deployed all the commando forces and everything is deployed over there, Milord. Now, Milord, number of arrests have been made, Milord. What we have done is now we are taking the entire video footage. A lot of video footage of the incident is available. On the basis of that, we are trying identification of. We have arrested a large number of people. The process is still on.
But these are all things which you are going to do after the incident. Should not this incident be prevented? What measures were taken? That is what is bothering us. So many emails have been received reporting about various. We don't want to. If we can ask those petitioners to file an affidavit. Some of them are petitioners.
I have my affidavit ready. But may I interfere, Milord, for a second? I think they will kindly bear with me. At 3 o'clock, this Honorable Court directed handing over the investigation to the CBI. Around 6 o'clock, that information received, I had to rush to the RG Court also, that they are demolishing the place of occurrence. That was the complaint. But I had rushed. I had also called up an advocate for the CBI that since the investigation is now under your control, it's your duty. Now, when I reached the spot, yes. Now, when I reached the spot, I found the doctors, agitators, students, they had become so much aggrieved, agitating. Then the demolition work was stopped, but a portion of it was demolished, admittedly, after the order of the Honorable High Court.
No,
And
this
then-
is not a correct submission, my lord.
Several attempts have been made, my lord.
Mr. Banerjee, let me narrate the incidents. If I am wrong, you correct me. I have no quarrel with that. Then, my lord, at the dead of night, when there was, my lord, a demonstration, some sort of spontaneous demonstration pan-India, the women who were gathering, they say the night is ours. At the 4 o'clock or 5 o'clock, the Honorable Chief Minister delivered a fiery speech, not only, my lord, targeting the lawyers, I forget about that, and said, you have demonstrated for 3-4 days. Now I will start a demonstration.
It's instruction to the council.
And at the dead of night, hooligans, 40-50 hooligans, maybe 70-80,
Not 7,000.
not 7,000.
Hardly
But they suddenly, my lord, attacked. The first attack, my lord, the place of demonstration by the doctors and students and youths. They demolished the entire Samiana, their stage, everything demolished. Then they entered into the hospital. Police were there, police outpost was there, police outpost was vandalized. I feel sorry to say the Calcutta police was so helpless. They got themselves hide behind the demonstrators so that the attack on the demonstrators be there, demonstrators would save themselves. And they vandalized the emergency ward. They went up to the 3rd floor was the instruction. 3rd floor means not the 4th story, according to us. 4th story is the place of occurrence. Unfortunately, they misread, then 3rd floor they arrived and demonstrate and demolished a part of it. Thereafter, it appears the police commissioner arrived there. When he was there on spot, still this hangama went on uninterrupted. And the police commissioner says, it's on record, that we had information that this might happen. But what can I do? There are demonstrations throughout the city. And I suffer from lack of logistical support. Look, this is on record video statement of the Commissioner of Police. But what is happening? Government hospital emergency ward is demolished to the ground. Police outpost demolished to the ground. ENT. But was it not pre-planned? Was it not the, my lord, if I may use that expression, my lord, the instigation by highest authority? Give them the bad name and kill them.
No, the second portion of your submission, we can't.
I'm just placing, my lordship may not.
On the first, probably, prima facie, it appears to be pre-planned.
Yes.
Otherwise, from what Mr. Banerjee says, on behalf of the state, that 7,000 people, if they have gathered, obviously it is 100% fake. Assuming that
this is
15 people have gathered, probably from a different angle, they would have entered the hospital premises. That is understandable.
But with humility, 7,000 is not the mystery. We never said that. We are saying, Malad, that mob, Malad, the demonstration swelled to 7,000. Out of which, Malad, as Mr. Banerjee,
what are they demonstrating for? In fact, the rapid action force should have prevented them from at least 1 kilometer before.
Was at that site where the rally was being taken care of. DYFI was putting up that
No, they have the responsibility, my lord, to differentiate between the mob as well as, my lord, the persons, doctors who are agitating, my lord.
But with your lordship's kind leave,
I will only make a
permitted-
prayer, my lord, let the CBI, my lord, also take up the investigation so far the vandalism is concerned.
Yes.
Because this is a part of.
But furthermore, my lord, I have made a prayer before your lordship, my lord, for deployment of central paramilitary forces. Because the situation is as such, it goes on record that the commissioner says that even after there was information, he was helpless. So considering the failure of the state machinery, my lord, the important essence of it is that, my lord, CBI has taken up the investigation. There is a crime scene in the Arjikar hospital. The police has failed to protect that. In view of such circumstances, my lord, I am humbly beseeching your lordship, my lord. I have also addressed a letter to your lordship via email, my lord, with such fact, my lord. And considering, my lord, the fact that Mr. Bhattacharya was addressing, I had also preferred a CAN application with regard to the crime scene that was being renovated in the name of innovation. Evidences were being wiped out. On the self-same day, I have made a complaint to the CBI authorities, and thereafter, my lord, I sought leave before your
May I
lordship
submit now?
to file a CAN application.
May I submit?
My lord,
A lot of submissions have
My
been
lord,
made.
with your
I
lordship's
thought I will
kindly,
not
my lord,
interrupt
if
anybody,
I may
but
just
not
add
things
to
are-
it, my lord, once, if I may just add to it once, my lord, and there were letters which have been addressed to the Secretary, Ministry of Home Affairs, Union of India,
yes,
and my lord, the director of CBI,
CBI.
by my lord, the leader of the opposition, in item number 2, my lord. The prayers are, my lord, that this is a continuation. So,
No, we'll-
my lord,
But
CBI
similarly, in item number 3.
Very small. In the last occasion, Lordship have observed that there is no complaint has been lodged by the principal and the authority. Millard, on that score, I could not apprise your Lordship. Millard,
You file an affidavit.
I am not in a position.
You file an affidavit.
No, I have.
You file an affidavit, sir.
Lodge. I have informed the police and.
You file an affidavit. Sir, you file an affidavit. Sir.
I think your Lordship the typical. Millard, your Lordship has made aspersion against Mr. Sandeep. Now there is incident happened on the Millard other. Millard, there were few people gathered in his house and wanted to set the fire. Millard, for
Why you seek police protection, sir?
No, we have already deployed.
even
Because we have made all our prima facie observations. We have also made a prima facie observation that your client is a very powerful person. So therefore, don't worry. Police will give you adequate.
it's possible that question doesn't come. Millard,
Yes, it does come. It does come.
Yes.
kindly give a
You challenge our order, sir. You challenge our order. You challenge our order. As we have signed, the order has been uploaded. It has to be implemented. Otherwise, we'll take suo motu contempt. If you want to bring on record anything, please file an affidavit. Let us test the correctness of your submission based on affidavit. Let him come and affirm an affidavit here. We will take it up.
Now, may I?
In the meantime, the state is with you. There's no problem. They'll post 500 policemen in your house. Nobody can set it on. If you don't trust the state police, please inform the court. We will request the central forces to guard your house.
I am all along with cooperating with the investigation agents.
We'll see, sir. We'll see. Nothing will happen. Nothing will happen. Let him be peaceful at home. Let him relax for some time.
Well, I believe Mr. Bhattacharya is appearing, Millard.
No.
You are appearing for the doctor. Yes, you file an affidavit.
For the doctor or his family, we have already taken steps for the court, the honorable single judge, we have taken leave to move a matter, on an urgent basis because, his entire house was, he was out, by a huge mob on the 15th, intervening night, 14th and 15th.
But you don't require a court order, sir.
No, we require.
No, they will take care.
Unfortunately, they have not. Unfortunately, they have not.
Definitely.
With deepest of respect, they have not. Now, therefore,
You move the single bench letters.
Yes, may I now submit? Well, I've been trying to submit for some time. First and foremost, may I say that as of now, and I say now, the PO is secure. All these allegations that the PO has been demolished, destroyed, nothing is
All right.
correct.
Then you
This-
file an affidavit.
I can
Yes.
one more thing, may I just say? As far as the demolition work that happened, that was not anyway, that was not in the PO or anywhere. That is for other room because there was a long-standing demand.
Sir, what was the urgency, sir?
The urgency is not, I'll tell you, Lord Chipolot, that is that it's a restroom for doctors. That has got nothing to do with the PO. This entire work that is carried on, I say.
All right, you go to any district court complex.
Yes.
You find out whether the ladies have got restroom. You go
That
to
is what
Siliguri.
is-
You
that
go
is
to
the-
Siliguri, sir.
But
No, I am not talking off my cuff.
no, I am saying,
I say this with responsibility.
yes.
And you are saying you go and visit the restrooms here.
Well,
What has the
today-
PWD done?
Today, when as far as the PO is concerned, the PO is fully secured.
Yes,
When the demolition
All
work
right,
carried out was outside,
All
much
right.
further
How
away from the
many
PO.
patients are there? We'll close down the hospital. We'll shift all the patients to some other government hospital. We'll convince the patient party to cooperate. We'll shift everybody, close the hospital. Close the hospital.
That's what only
How many patients are there? Close the hospital, that will be the best. And
This
all this story is saying that within 12 hours, restroom has to be provided.
No,
See
no,
the
this-
conditions, sir. See the condition in the court premises.
No, if I'm not, if PO is fully secured, I say it as of now.
We take
Not
it.
for the agitator's
Because
interest.
the entire submission, your lordship does not want to hear my submission.
Yes, sir, I will hear you,
But
sir.
my submission is, the issue is the PO. The PO I said as of now is also.
My lord,
There is no demolition work that has happened in the
Right,
PO.
so as of
I'm
now,
saying it
PO
with
is not the
responsibility
agitator.
and on instruction.
We take your word. You let this be on record by whoever is the dean of the hospital or administrator of the hospital. Let him file saying that nothing has been done. You support.
Nothing is in the PO.
Yes. And you can substantiate with photographs and you can say,
Yes.
and what was the work done? We are with an open mind, sir.
Yes.
But
But that's all I'm praying for.
Yes, you should also be disturbed as a citizen of West Bengal. Having been
When
born and brought up
submissions
here,
are made, when
you should
submissions
say,
are made with
yes,
that also
it should
disturbs.
pain you. It should pain you also.
Look,
It pains me.
It does pain us. But when incorrect submissions are made, then your lordship doesn't want to hear us, then it's a different
No,
thing.
it's not that way, sir.
Your
We have
lordship.
been here. We have been.
Sir, I am categorically saying the PO is secure as of now.
We will take your word. Take your word. You let an affidavit come on record saying that the PO is safe. CBI is under investigation. If they want, they can controvert. They can also examine. They will-
We have no problem. Let them go. Have they made that is the investigating agency. Have they come and said that PO has been demolished?
We have not taken up the issue today. The matter has been listed today because several requests have come by the writ petitioners themselves reporting about this vandalism. So this vandalism, could it have been prevented, is the moot question. Who did it, for what purpose it was did, etc. There's a vast difference between 35 people and 7,000 people. How many entered the hospital? What was the reason to, break all facilities in the emergency weeks? This can never be understood, sir.
May
I
I
don't
submit
think so.
this?
Such things has occurred in any other part of the
I
country.
have with me, well, it's just that I cannot show it to your lordship. The amount of resistance the police were putting up and how this
It
vandalism.
is true, sir. The police are also injured. That's
Yes,
sufficient.
even a rank of deputy commissioner has got injured, the other officers are also injured. So that is,
So
I am saying,
therefore,
but
Is
today,
it a failure of the law and order situation?
it is not.
that shows the helplessness of the state police authorities. And that is why we pray for deployment of central paramilitary forces.
Wait.
That is the.
Mr. Bakshi, please.
My lord.
Therefore, something should instill confidence in the mind of the court, sir. This
Just,
is,
if I may, just my point is, this situation is very unfortunate. What is happening? Both sides suffering. I'm a doctor from Calcutta, although I mostly live in USA. But these doctors strike. Now, more patients are dying. Poor patients. These doctors strike. Here's the Supreme Court. All I want, a Supreme Court order. We went.
no, we are going to hear the doctor.
No, it's different thing. It's different thing. And
Let him hold his patients, Milord. We are on a different.
Dr. Vai, you please file your
Well, he
petition.
stays in USA. He is so much interested in Calcutta affairs. That's significant.
Wait,
please,
Let us.
one.
you
We know you.
you should first
know you very well.
understand the agony your fraternity is going through.
Totally. I'm with them.
So
But
we will
not by
grant.
shutting down hospital. What is happening?
Yes, it has to be because
Only one hospital is
today
shut.
the
Strike is in the just one. What Supreme
No,
Court
we
said?
will not receive anything. You please file your
I will
papers.
list this matter on Monday as to be mentioned.
Yes,
To be mentioned.
Leave is granted.
leave is granted to file. Please sign.
Your lordship. Parallelly, a committee may be formed only for, your lordship, the condition of female doctors there who are working, who are studying is precarious. A judicial committee may be created only to suggest what state could take measures to improve the condition. This is required. Not only safety, plus the hygiene. Sexual Harassment Act, which has been brought in as a law. This is also workplace. The basic requirement of a human being is not being given to in any of the government hospital. The public toilets are worse than a gutter. I'm uttering this word, your lordship. As a public citizen, I cannot go to a public hospital for treatment because I do not want to be in such situation. But my state doctors are compelled to work there. because they want to study, they want to improve the society by giving them medical facility. So a judicial committee only to suggest, I'm not against the state.
All right, we will consider a prayer at the appropriate.
As a matter of fact, Mr. Banerjee, I don't think he was apprised of that, Malad. There were two acts, Malad. One was breakage of a wall, if your lordship remember. The first, the second.
No, that we'll go into conflict. Huh?
Yes.
Mr. Banerjee has told.
That was, Malad, as a matter of fact, of the joint decision taken by the protesting doctors and the hospital.
You bring on record.
What to carry out at that point of time after the CBI was.
The thing is,
I have that.
no,
it was not at the place of occurrence.
Just not in the
that is a the place of occurrence is completely secure. Yeah. Let the affidavit with photographs. No issues. Now, what is the issue is, if suppose this incident which occurred on 14th is repeated in any other institution, what like? So, if the police are injured, they are unable to control the mob, then the law and order situation has failed. That's it. That's the bottom line of it.
But may I say this? Definitely, but kindly, also keeps this in mind, Malad. This kind of, Malad, may I not say mob, demonstration has happened all over Calcutta. That
not a single one was it only over here that the violence broke out.
There were demonstrations all over, not only Calcutta.
Bigger in number than this. But everyone was peaceful.
If your lordship fought for your lordship, I cannot stand in the way. There might have been a lapse. But Malad, I am only trying to submit, Malad, that it has not occurred anywhere.
These were posted there.
Then why is this institution alone?
That's submitting, Malad. There was, Malad, what we found is, Malad,
সেদিন কথা বলিস এরা সেদিন কথা বলিস আর এই যেদিন এরা ফল পড়লো সেদিন কথা
that is what we are saying.
Kindly see them.
But just to repel the contentions of the state, my lord, I would just submit, my lord, that we are in, my lord, possession of video footages to show, my lord, that these demonstrators, these mob, my lord, they were carried, my lord, in lorries. The police granted them free access, my lord. We have the videos. We have referred to those videos also, my lord, in the application. This is nothing but a state-sponsored act, my lord, which was deliberately designed to, my lord, destroy the place of occurrence.
My lord, may I make a small submission? I have already, as your lordship knows, I have already taken out an application, which is unfortunately not, it has not yet been tagged. This is item number 337 of 2024. My lord, I have specifically asked that there needs to be institutional accountability, because at the heart of this entire matter is the question of an utter lack of institutional accountability. And it is unfortunate, my lord, that in 97, Vishakha judgment came. Vishakha came in the context and the backdrop of an infamous gang rape case. And after that, the Vishakha guidelines came. And after several years of struggle, the POSH Act even came into place. Aureliano Fernandez versus State of Goa is a judgment by the Honorable Supreme Court last year, where the Honorable Supreme Court has directed all state, has taken cognizance of the utter failure of institutional mechanism in West Bengal and across the board, all states and union territory administrations, and has asked all states to file a report informing about compliance with POSH mechanism. Unfortunately,
no, Madam Sen, this is a long-term plan. But the current situation is how to prevent such incidents in the near future. Probably tomorrow, day after tomorrow, next week.
My lord, may I?
It has gone beyond the control of the state police.
Indeed, my lord, I agree with your lord.
7,000 people is what they say.
My lord,
that's what we have listed the matter.
Yes.
The opportunity, my lord, may I just hand over to your lordship a video, my lord? Your lordship will see the sort of resistance we are facing.
What is that information? Well, they cannot control 7,000. You mean assuming that is correct?
How did this come back?
Outside the house.
It is not that we didn't have a force. Your Lordship will see the presence of the huge force.
This is a duty of the state intelligence.
After 2 hours.
But the way they are going on.
Means they failed.
These are all after the incident.
But the unfortunate police officers, my lord, who are seen in the video are nothing but cannon fodders, my lord. They are they are victims of a larger conspiracy, my lord. We have videos, my lord, to prove the contrary also. People moving in trucks, my lord, from Kamarhati and from Howrah.
And the police had given them safe passage.
My lord, the MHA, my lord, the Ministry of Home Affairs and the party responded, my lord.
The part
So they-
suggestion would be, my lord, the vandalism should also come under the purview of the CBI investigation, as you Lordship directed.
Absolutely.
Because this is related to, my lord, the
Now, in one of the writ petition, the doctor's body was impleted. Which is that case?
That was in item number 5, my lord.
5. 6 today. 6.
5, 6, 6, 6.
Is anybody representing them?
Let us be served with copies. I'm praying for that. I have not been served with anything.
But he says he has served.
Which one?
335, the doctors have been served through email.
Tickets with what is the number? I know, my lord.
335.
Yeah,
My lord,
Here, my lord, the best option would be, my lord, connect CCTV footages of all government hospitals to the local police stations. My lord, there is judgment of almost one-page judgment, my lord, for the security of the hospitals and their
রিকভারি মেডিকেল এতে যদি হয় এই আইনে বলা আছে যারা ভ্যান্ডাল
পরে আসবে আগে তো
security of doctors and the
টাইম বাউন্ড ম্যানারে তাহলে কার করা সাহস হবে
question of prevention.
এক্স্যাক্টলি ওখানে করা যাবে সব পেশেন্টকে শিফট করে দিয়ে খুলে দেয়
So this is an order passed by the Calcutta High Court. Paragraph 3, Miller. The security of the doctors and the nursing staff is of much importance, Miller. They were protesting peacefully, Miller. The RAF and the police force was attacked them, Miller. That should be secured first.
But did you serve?
Yes, Miller. We have served
Doctor's
through
body.
email. We have served through email. Miller, we have filed the affidavit service today. Miller.
There's nobody representing them.
Miller, as of now, we have no information.
But somebody can inform them
And the petition.
my lord,
saying that the court would like to hear them as well.
my lord, may I request WPA Pete 337 to be tagged with
Yes,
this?
yes.
And my lord, my prayer is very simple. Let the state submit a report bringing on record what it has done to prevent and prohibit.
No, that's Mr. Banerjee has said. He'll file an.
Not only
Please,
But
sir.
the-
We have served the copy. Serve again. We have
5 we have received, but 337 we have not.
337. Who was the petitioner? Please, sir.
339, my lord. On Monday it was filed, my lord. I have mentioned this on bench.
You please serve copies.
Not served.
339 in the list.
3399.
The issue now is, my lord, repetition, my lord, prevention of repetition.
339 is
Service.
339 is there in the list. You please serve copies.
may I?
What are you handing over? Your case is in the list, sir. Serve the government pleader.
Not only.
No, you are not to be heard.
Only one thing. My lord, apropos your lordship's order, my lord, the CBI wanted to, my lord, interrogate me in connection and pose me certain questions. My lord, they served on me this notice, my lord, in the evening. My lord, owing to, my lord, the outrage, my lord, outside my house, my lord, the mob violence. Outside my house, my lord, I could not go.
Then you make a
My lord,
prayer.
what I was humbly, my lord, I have made a prayer. I have indicated that I am going to cooperate and I am going to go today. But I thought, my lord, that the petition will be moved and, my lord, an order will. What I was humbly beseeching your lordship is some protection through any agency, my lord, state, central, my lord, to be granted to me.
Wait. If suppose your client is unable to move out of the house, which according to the learned government pleader may not be correct because he has been given sufficient protection.
No protection to Sandeep Ghosh.
No, you please give protection so that they will with a
We'll vote this
convoy, he can attend the office of CP.
about 10 H, yes, sir. 10 persons installed nearby with HRFS, which is the high radio frequency unit with them.
All right. He has to.
No, that is not Sandip. I am appearing for Dr. Sandip Ghosh in person. I mean, the doctor concerned who has been, directed to go on, leave. By your lordship's order, he is on leave. He has
Very
proceeded on leave.
So, if suppose you find it apprehensive to travel to CBI office to give the statement, state police will provide appropriate escort.
Kindly indicate.
That you provide.
Kindly indicate.
No, you make a prayer.
No, I have.
No, we don't want in somebody's writ petition. We can't be issuing this direction. We found your client to be a very powerful person. He is not power be exercised by himself with the state government. They will provide a pilot.
Had he been so powerful, he wouldn't have engaged us. You're engaging me, it shows that he's not powerful.
No.
That shows he is even more powerful.
I will not believe.
Engaging Mr. Bhattacharya shows that he is above the health
Even more.
secretary.
Suppose he has gone to the High Court Legal Services Committee and said that because of all these problems, please give us a panel counsel. Then it's when he is you, then it means he's got all the wherewithal. They will definitely provide you. He will not. Yes, sir.
The issue has handed.
Sir, Mr. Bhattacharya, ASG is making some. That will be given. Then what we can suggest is, let the special team visit the hospital, because government has taken a clear stand that the place of occurrence is intact. You just assess what is the type of damages which have occurred, etc. Whether how long it will take for the hospital to come back to normal, because the extent of damage is severe. The extent of damage is severe. All life-saving have been
not all, not
broken.
only the rest of the emergency.
No. Emergency is the first place.
I don't have the full instructions about the state of the hospital, but I will not make a submission in court. But all I can say is, I will put it when I'm filing the affidavit. I shall also find out department-wise how many are functional, how many is left untouched without any damage. I shall give that in my affidavit.
How is it relevant? How is it relevant?
No, let your officers visit, sir. They have informed about the incident. Let your investigating team visit. You don't require an order to how you have to proceed with the investigation. Please.
Without taking instruction, my learned friend is making submission. Is it a submission that the PO has been damaged? I want to know.
Yes. The matters have been listed under the caption to be mentioned and shown in the supplementary cost list. The reason being that this court received several representations from the writ petitioners reporting about an incident, an unfortunate incident which occurred in the hospital premises at about 11:45 p.m. No, at about 12:30 a.m. on 15th of August 2024, when a large mob entered the hospital premises and vandalized the emergency and other departments in the hospital. The learned senior standing counsel appearing for the state could submit that about 7,000 people had gathered, and on account of the unruly situation, Several policemen were also injured. And so far as the state police is concerned, they have taken effective steps but to prevent the mob. But the gathering was so large. There was total chaos, totally a chaotic situation. The learned senior standing counsel will further submit that the place of occurrence, which is stated to be in the 4th floor of the building, is intact and no damage has been done to the said premises. The learned advocates appearing for the petitioners would submit that indeed there was an attempt to damage a portion of the 4th floor, and after protest, it appears to have been stopped. To assess so far as the investigation is concerned, the learned additional solicitor general on instruction submits that a special team has been constituted who are proceeding with the matter, and the CBI has also been intimated about the unfortunate incident which took place at the early hours on 15th of August 2024. In our view, the police should place on record the entire sequence of events which ultimately led to the unfortunate incident. That apart, what is more important is that the doctors working in the hospital who are presently presently protesting have to be given adequate protection, or else they would not be in a position to discharge their duties. Though in our earlier order, we had made an appeal to the joint action body of the doctors to reminding them of their pious obligation in treating the patients who come to the government hospital. However, the incident which took place on the early hours on 15th of August 2024 would definitely have an impact on the mindset of the doctors who are presently protesting. In WPAP 335 of 2024, the doctors' body has been implemented and service has been effected through email. We direct the learned advocate for the petitioner to inform the convener or any person responsible, any person who is in charge of the affairs of the joint action group, so that they can be represented before this court on the next hearing date. The CBI is at liberty to visit the hospital premises and make an assessment and proceed with the investigation as they deem appropriate. We direct the appropriate authority of our police authorities as well as the administrator of the hospital to and the person in charge of the hospital to file 2 separate affidavits narrating about the true state of affairs and all matters incidental and connected therewith. Let this affidavit be and let advance copy of this affidavit be served on the learned advocates for the writ petitioner and filed before this court on the next hearing date. List.
My lord,
the investigating team as constituted by the central CBI shall also file an interim report as regards the progress of the matter.
Your Lordship, one thing.
my lord, 337.
The next date of
Only one
But only one thing, my lord, with regard to the deployment of central paramilitary forces, my lord, considering the situation as of now.
My Lordship, the victims' photographs are circulating in social media. A general guideline, maybe not a guideline, it could be included. It could be included that not to circulate.
Is it so?
To take action.
Yes.
No, the victims' parents are here.
Your Lordship,
You don't have better interest than them.
No, not.
By the friends and others, they are circulating, but probably they do not know the legal implication of
All right. It is submitted by one of the learned advocate appearing for a public interest litigant that the photograph of the victim is being widely circulated in the social media. As the law prohibits the disclosure of the identity of such victim, we request we request the persons who are known to the victim not to circulate the photographs of the victim
And name.
as well as the name and other identity and details of the victim.
Well, everyone, anybody
Everyone.
from disclosing. Because
Including all citizens.
Because everyone, because
It's a guideline by the Supreme Court.
That will be like a John Doe order. That will be like a John Doe order.
There will be just an induction.
Equally, we would request the members of the press and media also to ensure that the identity of the victim or the photograph of the victim shall not be published in any of the reports.
And social media.
That we have.
My lord,
I am a party by name in one of the writ petitions. One sentence.
Yes, in my writ petition. In my writ petition.
my lord, 337 name, 337 may be added.
As your
Tag with this.
Your Lordship is keeping this matter on.
And my lord, I have already served the copies.
You have to ensure that copies are served on the government leader. During the course of the day, you obtain, acknowledgement.
It is on Sartha, copy has been served, my lord.
If it is not served, you send one of your colleagues to the government leader's office, ensure that it is served.
I will do so.
Then if the government leader says, yes, it's served, well and good. Yes, we have said that.
But your Lordship is keeping this matter on Tuesday. Affidavit to be filed by Tuesday.
No, Tuesday you file it in court. By Monday evening, you circulate soft copies. Well, if government leader wants, he will do it.
Kindly forgives me, kindly may not scolds me, do whatever. Kindly records my submission that I have made this submission, nothing.
As of now, we are not.
Very well, as your lordship.
Let him, as you rightly said, your client is cooperating. He will cooperate. State will provide him police pilot and escort. Take him there.
Pilot, no. He is not so powerful that he is entitled to a pilot.
In case, one more option. In case he still has the fear psychosis, to invite CBI officers to his residence.
Yes.
They can also see how well you have maintained your residence.
I have a humble appeal that may it be Wednesday instead of Tuesday. Tuesday, the Supreme Court matter is fixed.
All right, Wednesday.
Well, deeply.
Yes, we are agreeable. Let the CBI officer visit my house.
No, the first is, see, wait. If the CBI officers come there, there will be a lot of the other commotion. Public will there. The local auto rickshaw drivers will inform. And the neighbors also, their perception of the entire situation will be different. Police has come.
Right. Very amazed.
So that will damage.
With the live telecast, everybody.
But not him. But
it is difficult for us.
His family.
Yes. His family is more trouble.
That's it.
He has a 5-year-old kid.
If these persons visit them, obviously it won't be in uniform.
I'll make an endeavor to, not.
You handle it.
The hospital authorities to be filed any affidavit.
Supplementary affidavit. Sir, supplementary, madam. Supplementary affidavit. Have you served copy?
When? No, sir. But I'm sitting.
May I humbly beseech your lordship, with regard to
Yes, we'll go stage by stage, Mr. Bakshi.
Yes, ma'am. Madam, consider the aspect of the next date of hearing, madam.
Yes, supplementary affidavit has been filed by the writ petitioner in WPAP 339 of 2024, which is taken on record, and the learned advocate for the petitioner is directed to serve copies on the respondents, more particularly in the office of the learned government pleader.
By today.
By 3 p.m. today. Very good. 3:30 p.m. today.
I'm there, but I still.
No, by today, as long as it's given by today, but we are all there.
But I'm there, always.
Well, a copy may be given to the hospital authority.
Oh, yes, our respondents and in particular to the office of the learned. All respondents. What is this? There is scissors. CBI is given some sealed cover. It is handed over to the Registrar General. Oh, this is the copy of the FIR registered by CBI along with the copy of the court order. The CBI had submitted a sealed cover addressed to the Registrar General of this court. The cover was placed before us today and it was opened, and it contains the first information report registered by CBI dated 13/8/2024. Along with the copy of the order passed in these petitions dated 13/8/2024. Copy of the first information report registered by the Tala police station.
But that is done by me.
No, we are just saying enclosures.
Case number 160.
Copy of the complaint dated 9/8/2024, which is in regional language. The FIR and the annexures be kept on record. Cover also. So Wednesday it will come.
But since my lords are making it returnable on Wednesday, but may I just humbly suggest this, my lord, that since my lords are also exploring, my lord, about protecting these particular hospitals, and since the Ministry of Home Affairs is already a party respondent, on the next day, my lord, if they can also come back with their inputs as regards deployment of central forces, my lord, in the event, my lord, the court also desires.
At this stage, we don't want to make any observation. Let this affidavit be on record. Mr. Banerjee, yes, sir. On Wednesday, we will see.
My lord.
Yes.
My lord, will your lordship be kind enough to grant me leave in this matter, my lord, on the self-same cause of action to file it and come on to Wednesday, my lord? I will serve the copy to the London Government of Leaders Office by today, my lord.
Now itself, right and now.
Also,
Yours also.
My lordship.
All of you file, don't derail the entire matter. That's it.
No,
and they will say affidavit in opposition, reply, exception, report.
Today or else I will withdraw, my lord.
And
by today.
By then I will retire.
We will file our affidavit, reports in the form of affidavit, Your Lordship. Not deal with all these hundreds of petitions.
Almost the allegations are identical in all.
Yes,
but if we have to deal with them, then
no.
We'll file one comprehensive affidavit on the factual.
Called by Your Lordship.
Chronologically, as you were.
Yes.
Chronologically.
Yes, we shall do it.
That
what that?
My lordship, I am a Konika ready to welcome.
So we will take up original side matter. By then they will organize the files. We'll go back for 5 minutes and then this one also.
मेरे घर में ऐड टू कार्ट नहीं, ऐड टू किचन होता है।
डोसा, रवा इडली, वड़ा।
बनाओ असली साउथ इंडियन खाना घर पे MTR के साउथ इंडियन रेंज के साथ।
হয়ে যাক তখন আমরা
15 minutes
কোনটা কোথায় আমি ওটা আপনাদের ঘাড়ে কি মেনশন করেছি জানি না is that the appellant number 1 and appellant number 2 are husband and wife. They have purchased a health insurance policy commonly called floater plan in the year 2019. Initially, that policy was of 2 years, 19 to 21. Thereafter, it was extended for 21-22, then 22-23. Now, in the year 2023, on 8th of April 2023, this appellant number 1 was admitted for coronary bypass surgery. My lord, he was admitted, bill was raised of about 3 lakhs and odd. The claim was made. The claim was rejected by an email dated 1st June 2023 by the respondent number 2, stating that in the year 2018, that is prior to the commencement of the policy, you had a total bilateral hip replacement for which we cannot honor your claim. Now, my lord, this policy which this appellant number 1 has taken is through online mode. My lord, there's a categorical statement made that entire facts, including the disclosure of this earlier operation, was being disclosed. Now, my lord, thereafter, my lord, in the year 2022, this appellant number 1 had a psychotic eye treatment. In course of that treatment also, my lord, this treatment of 2018 was disclosed. The medical document to that effect has been annexed, my lord. Now, my lord, the complaint was made with the respondent number 1. The respondent number 1 relying on one tally verification call, my lord, which was neither handed over to me, not shown to me. My lord, rejected my claim. Now, I beseech your lordship to, my lord, I'll show your lordship the order passed by the ombudsman, my lord. Now, that is at page number 86. It starts from 86, my lord. The ordering portion is at page number 87, last paragraph. It is observed from the contention of both the parties and on perusal of the documents, the complainant had not disclosed the material facts about the health condition of the insured person. Even in the absence of any proposal form, the tele-verification call also does not evidence declaration by the insured. The insurance policy, being a contract of utmost good faith, is based on the details given by the insured to the insurer, which makes the risks acceptable for the insurer. Non-disclosure is a violation of the basic principle of the insurance and terms and conditions of the policy. Taking into consideration the facts and circumstances of the case, the contention made by the parties, and on perusal of the documents on record, it is observed that the complainant had not disclosed his medical history at the time of taking policy, nor declared the same during the tele-verification call, which is violation of the policy terms and condition and basic principle of the insurance contract. Hence, the repudiation of the claim made by the respondent is justified and the complainant is dismissed without any relief to the complainant. Now, I beseech your lordship to take one medical document of 2022 of the respondent of the appellant number 1, wherein the claim was honored, and also a prescription wherein the treatment of 2018 was also disclosed, my lord. But first, I'll take your lordship to page number 59. My lord will find this document has been issued by the respondent number 2 addressed to Calcutta Medical Research Institute. My lord will find date 5th August 2022. From patient name is the appellant number 1. The treatment is ischemic optic neuro unspecified eye. Hospitalization duration 26 July 2022 to 30th July 2022. Now, they have honored this claim. Now, I beseech your lordship to kindly turn up to page number 111. This is a document, my lord. 111, your lordship. 111. 111.
Yes. This folded annexure E.
Annexure F, your lordship. My lord, with regard to same neuropathic eye treatment, my lord, issued by the CMRI in favor of Mr. Pralay Shankar Dhar, my lord will find in the bottom THR 2018. Total hip replacement 2018. So my contention is that, my lord, this policy.
No. The case is, did you, under the appropriate column, while applying for the insurance, because
lord.
this is an online mode,
My lord,
did you disclose?
it was disclosed, my lord.
You show that form.
My lord, since this was being the online, my lord, the policy was purchased through tele-verification call. But there was no written proposal form. And my lord, to that effect, there is a regulation called Insurance Regulatory and Development Authority of India. My lord, may I hand over a copy of the regulation. I'm placing reliance on Regulation 8.2. Now, there was no written proposal form. The policy was purchased through online mode through tele-verification. I have categorically made statement that all disclosure was made. Even I have offered myself that you check whatever you want to before issuance of policy. My lord will kindly take up Regulation 8.2. Now, running page
19.
Running page 19, your lordship. In case of marine insurance cover or other insurance cover, where a proposal form is not used, my lord, this is my case. The insurer shall record the information obtained orally or in writing electronically and confirm it within a period of 15 days thereof with the prospect and incorporate the information in its cover note of policy. Where the insurer claims that the prospect suppress any material information or provided misleading or false information on any matter material to grant of a cover, then the onus of proof rests with the insurer only in respect of any information not so recorded. Now, I beseech your lordship to kindly also take the transcript, how they have recorded my voice, my lord, at the time of selling the policy. So that is also totally observed. My lord will kindly take a page 48.
48.
My lord. Running page 48. My lord, this is the first insurance policy I've told your lordship I purchased in 2019. My lord will find date, period of insurance on the top right hand side corner, 2021. Now, lordship will kindly take up the transcript portion. That is at page number 49. Now, my lord will find introduction. Good morning, sir and madam. Am I speaking to Mr. Pralay Shankar Dhar on phone number so and so? I am Kundan Kumar and AV certificate number so and so of HDFC Bank and corporate agency. This call is regarding my health insurance Silver Smart. Customer response okay. This cannot be an okay. I will be either be saying good morning or something like that. It is only okay, okay, yes, okay, yes. So, my lord, this is also observed. Now, my lord, I am asking to myself. Now, taking it.
Now, you come to the column pre-existing declaration.
Yes, my lord, pre-existing declaration.
What is your answer? Have any of the persons proposed to be insured ever suffered from, currently suffering from any disease, ailment, medical condition, illness, accident or injury?
The answer is okay. It cannot be okay, my lord.
How it can be okay? That's what the learned judge says.
No, but it's this is their recording, my lord. This is the insurance company is what they have recorded. And my lord, I am asking to myself, insurance cover, my lords know health insurance specially. It is being, my lord, renewed year to year. This first policy started in 2019. 2021, it lapses, my lord. Further, I have renewed in 2021, which continued to 2022.
Suppose,
my lord,
on this tele-verification, if he had mentioned that he is a diabetic, he has undergone both hip surgery. Obviously, the insurer will not record okay.
No, my lord will kindly also see the answers yes, no, okay. My lord, they have not recorded anything what I have stated.
We can't test all those things in a record.
No, my lord, that's true. My lord, I'm not on this. Only my contention is
but,
that
probably if you had gone to a civil forum.
No, my lord, my contention is that they have relied on tele-verification call. My lord, in the
and moreover, this is a private insurance company.
My lord, order which I have challenged is of insurance ombudsman. My lord, guided by judgment, my lord, which I will be showing. My lord, my first contention is the violation of the principle of natural justice. My lord, regulation 15 of the insurance ombudsman rule, my lord, requires the respondent number 1, who is the insurance ombudsman, to act fairly and equitably, my lord. My lord, may I place regulation 15, my lord. The ombudsman may, if he deems fit, allow the complaint to adopt a procedure other than the sub-rule 1 or sub-rule 2 of rule 14 in making a complaint. My lord, I'm directly jumping into, my lord, rule 4, my lord. The ombudsman shall dispose of a complaint after giving the parties to the dispute a reasonable opportunity of being heard. Now, there's a gross principle of natural justice. A document, a material has been relied upon by the respondent number one being the tele-verification call, which was neither shown, neither the copy was provided. But Regulation 17 says that the award should be passed based on the pleading and evidence based on record. May I hand over a book, my lord? My lord, the insurance company would have refused to renew my policy in the year 2023.
No, the earlier policy was a life insurance policy.
My lord?
The earlier policy was a life insurance policy.
No, earlier policy was
the
the health
present-
insurance.
Huh?
Health insurance, my lord.
No, the learned judge has recorded
No,
the contention, page 106, second paragraph,
my lord, may.
has recorded the contention of the insurance company, points out that the same pertains only to
My lord is reading
Disabled.
internal page 2 of the order.
3.
Internal page 3, my lord. Learned counsel appearance for the insurance company. No, my lord, the reason why this has been stated, initially I have relied upon section 45 of the Insurance Act, which states that the policy cannot be called into any question, even if there is a misstatement after a period of 2 years from the issuance of that policy. That is section 45 of the Insurance Act says. Now, my lord, this was a contention that section 45 of the Insurance Act only applies to life insurance policy and not to health insurance. Now, this is the health insurance policy, my lord. My lord, I concede, my lord, to that legal proposition that has also been, my lord, upheld by the Honorable Supreme Court, that the section 45 will only apply to the life insurance policy. Now, my lord, kindly visualize the situation, my lord. 2019, I purchased a policy. Twice they have honored the claim. In course of honoring my claim, I have disclosed, even at the time of purchase, I have disclosed that I have a total hip replacement policy, replacement in the year 2018, my lord. That is, medical document is there.
Yeah, assuming it was disclosed or not disclosed,
My lord.
this is a fresh policy.
No, this is not the fresh
All right, renewal.
No, continuation.
But then subsequently they come to know that this particular pre-existing sickness or pre-existing health condition was not.
My lord, that is my argument. In the year 2000, not subsequently, my lord, in the year 2022, in case of my treatment of ischemic naturopathic eye treatment, I have annexed the document, my lord, which I have shown in page 111. So total hip replacement, and my lord, it's a kind of treatment, my lord, no one can suppress. Even in X-ray machine or in USG, if I go, because various iron parts are there, my lord.
But then he has not subjected himself to a medical examination before the policy was
My lord,
issued.
that I have categorically stated, my lord, will kindly take a page number.
This is the risk you undergo,
No, my lord,
undertake when you have a tele policy.
my lord will kindly appreciate regulation 8.2. My lord, that is the reason, my lord, these regulations are being framed that when there is no written insurance policy, the onus of separation and materials.
No, assuming there was a, they honored an earlier claim.
My lord.
There cannot be any.
My lord, honor of, that's true, my lord. But in course of the honoring of claim, had I been the bad intention or there was no mens rea, I would have not disclosed, my lord, these facts. And further, if my lord will see regulation 8.2, it is a contention made at their instance that I have made separation. But onus is upon them. Number 3, my lord, the insurance ombudsman had relied upon one tele verification call. My lord, what I have stated, what I have not stated, and I've also shown, my lord, the transcript, which is also absurd, my lord. My lord will appreciate regulation 17 at the time of passing the award. The insurance ombudsman is required to rely upon the concise statement and the evidence. But no evidence was there, my lord. Even if I don't ask, my lord, they are required to provide me the copy. My lord, I am a senior citizen, my lord. Right from 2019, they are taking money from me. And my 2023, they are stating that in 2018, you have got a treatment of total hip replacement. And my lord will also appreciate the treatment with regard to 2023 was coronary artery, having no connection with total hip replacement, my lord.
You can't say. No? That is up to the insurer. That you can't say.
Well, only contention which I am trying to and harness upon your lordship that I have never suppressed, nor there was any mens rea. Guilty mind, my lord. Had there been any guilty mind, the subsequent treatment and the medical document would not have stated, my lord, that there was a total hip replacement. They could not have renewed my policy. Why they have chosen to renew the policy? In the year 2022, they have further renewed my policy, knowing very well that THR operation was there. So second contention, my lord will also appreciate the language of regulation 8.2. They have chosen to issue me a policy without a proposal form. Not only mine, they have also my lord, cancelled the entire policy, my lord, of my wife. Well, apparently, my lord, there is a violation.
If you had taken a such a health medical insurance with any public sector insurance company,
My lord.
they would not have granted the policy without a full-fledged medical examination by
My
their
lord.
panel doctor.
No, that is,
This
my lord,
is their
no, that is for the, my lord will kindly appreciate, this is for the insurance company for medical tests. When there's a categorical statement made by the applicant in the writ petition that I have offered them to, at the time of purchasing policy, that whatever test you want to, you can do. Further, my lord, I have a categorical statement that this total hip replacement, which I have undergone in the year 2018, was also disclosed to them. No, my lord, the third point is that even in the course of my treatment in the year 2009-20,
when this question and answers, no, where is it? Page 58.
my lord. Page 49, your lord.
49.
My lord. Now that learned single judge, my lord, has stated that it's an absurd, my lord. He is not relying upon this. My lord,
No.
My lord.
If suppose this was given to you at that point of time, along with the policy,
my lord,
you should have.
I have to, but my cause of action had arose in my lord in the year 2000.
You should have pointed out this is wrong recording. It's not okay.
My lord.
You please change. This is what I have said.
My lord, that's true, my lord. But my cause of action for the writ petition has already arose in the year 2000.
Maybe, but then
2023. By that time, my lord, this policy was not there because that was renewed, my lord. This transcript was not there. My lord will kindly appreciate, my lord, a senior citizen making payments since last. Further, there was no guilty mind or menshria. In 2022, he had undergone the treatment of
but you see,
neuropathy unspecified.
Purely a contract.
It's a contract, but my lord, only also kindly consider.
Yeah, because but for the order passed by the ombudsman, writ petition was not maintainable.
Well, writ petition, but there is a prima facie violation of the principle of natural justice, my lord. Writ petition ought to have been maintained.
I expect the ombudsman to write a judgment.
Well, that's true, but he's relying upon the tele-verification call. My lord will also appreciate regulations 17, my lord, which I've handed over to your lordship, that the award should be passed based on the pleading and the evidence.
The reasoning given by the learned judge is appropriate.
My lord will kindly contention, my lord will kindly record my lord will kindly appreciate, my lord, 2019, my lord, I purchased the policy treatment where there I've disclosed everything. This insurance company ought to have declined for the renewable. Why they have renewed, even knowing that there was a THR 18. Let's take it, my lord, I have not disclosed, I have suppressed everything. Then, my lord, in the year 2022, when I had undergone this ischemic optic neuropathy unspecified eye treatment, they have honored the claim. Medical document also shows. Thereafter, my second term expires. Thirdly, they chosen to renew it. And my lord will also consider regulation 8.2, my lord. Well, the onus is totally upon them to show that I have suppressed when there is no proposal form.
Page 80 is the
page
80.
80.
That's where they repudiate. What do they say?
My lord will
policy is cancelled. Claim is repudiated due to non-disclosure.
Hello, it's that page 80. Yes, page 80.
And concealment of fact under section D4 of the policy terms and conditions.
They have said it as per the document submitted. Patients was admitted on 8th April 2023 for the treatment of coronary artery disease. Patient has history of bilateral total hip replacement 2018 before the first inception date of the policy 1st 12 2019. Hence the policy is cancelled and the claim is repudiated due to non-disclosure. The point which they have taken is that I have undergone a total hip replacement policy in the year 2018, my lord. That is prior to the inception of the policy. For last 4 years, they are renewing the policy. They are honoring the claim. In course of treatment, they very well knew that THR 18 was done in the year 2018. Then I'm asking to myself why they have chosen to further extend it in the year 2020-23. When there's a categorical statement that I have all through disclose everything. And in course of hearing before the respondent number 1, documents, materials were being relied, neither discuss nothing. I have been served with this order that it has been rejected because one tele-verification call. I don't know what tele-verification call was there.
Sorry, sir. Please come. This intra-court appeal by the writ petitioner is directed against the order dated 1st May 2024 in WPO 308 of 2024. The appellant writ petitioners challenged the order passed by the insurance ombudsman, who affirmed the order passed by the respondent private insurance company, repudiating the insurance claim made by the first appellant. The learned advocate appearing for the appellant would vehemently contend that the order passed by the ombudsman is wholly untenable without taking into the factual situation.
My lord, I consider to remand it to the ombudsman, my lord.
Factual contention.
What verification calls, my lord?
And the order is in violation of the principles of natural justice. The respondent insurance company before the learned single bench contended that the repudiation of the policy was on account of non-disclosure of the double hip replacement surgery done on the first appellant during the year 2018. The contention of the appellant was that the policy was renewed once, and in between, the appellant made a claim for undergoing eye surgery, which was approved, and amount was sanctioned. Further, it is submitted that reliance has been placed on Regulation 8 within bracket 2 of the Insurance Regulatory and Development Authority of India. In Regulation 8 within bracket 2 of the Insurance Regulatory Development Authority of India within bracket Protection of Policyholders' Interests bracket close Regulation 2017. The learned single bench had extensively considered the factual matrix and also dealt with the effect of Regulation 8 within bracket 2 of the Act. In our view, the learned writ court also took note of the transcript of the voice conversation between the parties, and was of the view that the answer okay for one of the questions as regards the pre-existing health condition was not an appropriate answer. That apart, the issue that the insurer had honored two policies previously was also considered and rightly held that it cannot be elevated to the high status of acquiescence or waiver on the part of the insurer, since an act of waiver constitutes an act which is done with full knowledge of fact which is sought to be waived. The reference was made to the decision of the Honorable Supreme Court in the case of Satwant Kaur Sandhu versus New India Assurance Company Limited, 2009 ATCC 316. It is there in page 106. And the learned single bench noted paragraph 16 of the said judgment, wherein the Honorable Supreme Court held that the materiality of the fact which is alleged to be suppressed depends not on the present claim or the nature of the same, but on whether the suppression had a bearing on the insurer being agreeable to accept the risk at all or in fixing the premium for the insurance policy. With regard to the double hip replacement surgery performed on the first appellant in the year 2019, the learned single bench was right in observing that this is undoubtedly a matter of serious importance, since the fixation of premium and/or the decision of the insurer to accept the policy in the first place would directly be linked with such disclosure. The effect of Regulation 2(8) within bracket 2 was also considered, and it was held that the and held that the on account of suppression of the material facts, the petitioners would not be entitled to any equitable relief in a writ petition. Thus, we find the reasoning given by the learned single bench are just and proper and does not call for any interference. For the above reason, the appeal stands dismissed. Some late pollution.
Item number 3.
This is, my lord, it's relating to the, my lord, tram. My lord, we had brought it to your lordship's notice that in spite of your lordship's order, they were bituminizing the existing tram tracks.
That was some newspaper report.
Yes, my lord. We have also affirmed a contempt application. Now the problem is that lordship is hearing two matters. One in the appellate side, other is on the original side where I am appearing. The order restraining them from further bituminization has been passed by your lordship in the appellate side matter.
So
my
you
lord,
call for that also?
Yes, my lord. When we go to file this contempt application in our matter, bringing the notice of the court, my lord, department is not accepting the contempt
Because
application.
the order was not passed here.
In this one. But
you file it in the appellate side matter.
I cannot file because there I am not the petitioner. Because there are judgments to that effect that anyone can come up before the court and this may
What
be...
is the response of the state?
Mr. Siddiqui is the counsel engaged in the matter, but whatever my instructions are, that we are going to keep a portion of the tracks for trams, and that is the instructions. We are going to file an application by next week. To the extent which
in which case you are going to file in the other?
In the originals.
You file an affidavit?
And just in the meantime, I take this number.
Yes, we can. Kindly keeps it after 2 weeks. By next week, we'll be filing this application and everything can be brought on record.
Your oral instruction is you are not going to remove the tracks?
No, not to the extent to a particular portion the trams will apply, but not for the entirety of the portion.
Then you have to get the order modified.
Yes, that is the application.
Then until then you don't do anything. They are filing a contempt petition.
Lordship kindly keeps it on. Then next week by this.
And have you got the order passed in the appellate side matter?
Yes.
Where?
That is petition to them.
You give a copy of that order.
Petition to them.
Today, your lordship.
What is this?
The affirmed petition where the order is annexed.
That order is sufficient.
I think it will be there in the appellate side matter.
In the list today.
Yes.
Order dated 8th of May.
8th May 2023. WPA 214.
This matter, please take down, sir. As was mentioned before this court for a early hearing, and accordingly the matter is listed. Both the matters are listed. In WPAP 214 of 2023,
paragraph 6.
Which was filed in the appellate side. This court had passed an order on 8/5/2023, making it clear that the respondents shall not carry out further bituminizing or removing the tram tracks, and nothing should be done till a decision is taken by this court in the writ petition. The learned advocate appearing for the petitioner in WPOP 12 of 2023 submits that this order is sought to be violated by the respondents, and news reports are widely circulated that the tram tracks are to be removed and bituminization process is to be carried on. In fact, the petitioner in WPOP 12 of 2022 proposed to file a contempt petition, but however the same could not be presented in the department since the interim order was passed in WPA P214 of 2023, which was filed in the appellate side. The learned advocate appearing for the respondents submitted that the respondents are in the process of filing an appropriate application. And the oral instruction given is that the entire tram tracks are not proposed to be removed, but they will be made to ply in specified areas. As long as the order dated 8/5/2023 has not been varied or modified, the respondents are bound to comply with the same in its letter and spirit. In the event there is violation, then the respondents are exposing themselves to action under the Contempt of Courts Act. Therefore, the respondents are directed to strictly comply with the order dated 8/5/2023 in WPA P214 of 2023. The respondents are at liberty to file appropriate application if they so desire.
My lord, may I seek leave to file this in the original site, my lord?
No,
Leave may be
not
granted.
required. You have said so.
My lord, we have affirmed, my lord, it is ready, my lord. We just
Technically, it is not maintainable. No, we are hearing you. We are here. Don't worry. Next. Next.
Item number 4.
My lord, in item number 4, 5, and 6, my lord. In item number 4, 5, and 6, my lord, I am for the appellant lordship. I'm not well. That's the reason I could not come to court. If your lordship kindly takes up this matter on the next day, my lord.
All right. At the request of the learned advocate, the appellant. 4, 5, and 6.
4, 5.
4, 5, and 6. Now, there are other matters also. May I mention right now or at the time of call, if your lordship so directs?
Well, item number 11, 12 also, my learned
He is
friend.
not well, Mr.
Oh, so 11, 12 also, I don't think he will be doing the matter today.
All right. 11 and 12 also.
11, 12.
11, 12, and 13. 11 to 10, 10, 11, 12, 13. Up to 17, my lord. Up to 17. 10 to 17.
All right. Let it remain in the list. Why we should adjourn? Not today.
My
Not today, not today. Only make it not today.
We'll say it not today. Subject to your convenience, we'll take it up.
Yes. 10 to 17, total, not today. 10 to 17, Mr. Day is appearing.
He is not well.
10 to 24 to 10 to 17.
All right. Any matter where both sides are ready?
Both sides are ready. 24.
24 is also, he is appearing in 24 appellant.
He can't come to court today.
All right. Only my prayer is that it will be the next Friday. I will not be here.
All right. On that day, somebody can represent. We will adjourn it. Okay. Otherwise, to take it out of the list, etc.
Today I will mention.
In anybody in that Casta appeals.
My lord, in item number, my lord, 20, my lord, we have served twice, my lord, but could not succeed, my lord. If your lordship kindly direct us to serve it through the department, we want to take some as a last chance, my lord, so that it can be done.
All right.
Item 21, my
Item
lord.
21, no?
21. 20, my lord, sorry. Item
20.
20.
The appellant directed to serve fresh notice on the respondent through the department.
My lord, since it has been submitted that the notice which have been served was returned back.
Since the notice which was sent has returned.
My lord, item number 18, my lord, both we are appearing, my lord. To be very candid, if your lordship, this issue has also decided by your lordship in another appeal. If your lordship kindly consider this.
For the orders of
18.
18, my lord.
18.
Commissioner versus
I am led by Mr. Sivagnanam Banerjee, my lord. It's a case of, my lord, fire broke out in the premises where the factory of the respondent situated. Due to devastating fire, entire finished, semi-finished product was destroyed. Thereafter, they filed a remission application under Rule 20 of the Central Excise Rule 21. So that was rejected. Subsequently, they preferred an appeal before the Planet Tribunal. When Tribunal had allowed against this, my lord, we have preferred this appeal, and that my learned friend George handed over that order Sorbovary impact. This is the same premises where that both the companies situated. If your lordship kindly consider this. Question of law.
Ah, yes, we remember.
Yes, my lord, it is
Yes, that is, this is
Same premises.
same premises.
both matters were taken up together by the learned
That's
tribunal
right.
below.
All right.
And my lord would find that order at page 39.
39, yes. Please come, sir. This appeal has been filed by the Central Excise Department, Central Excise and Service Tax Department under section 35 capital G of the Central Excise Act 1944 within bracket the Act against the order dated 26/7/2023 passed by the
Same order.
Customs, Excise and Service Tax Appellate Tribunal, Calcutta within bracket Tribunal in Excise Appeal number 75332 of 2017. The revenue has raised the appellant has raised the following substantial questions of law.
Page 22, my lord.
Page
22 of the state petition.
questions of law for consideration. A, B, D, capital E, A, B, D. We have heard Mr. Sivagnanam Banerjee, Senior Standing Counsel for the assisted by Mr. Tapan Banja, Junior Standing Counsel for the appellant, and Mr. Sonso Mukherjee, a learned advocate, appearing for the respondent. The tribunal, by the impugned order, allowed dismissed 2 appeals filed by the department, namely Excise Appeal number 75332 of 2017 and Excise Appeal number 75461 of 2017. As against the order passed in Excise Appeal number 75332 of 2017, the department had filed an appeal before this court in Sexa 5 of 2024, and by judgment dated 9th July 2024, the appeal was dismissed. The operative this compilation, which has been filed by the page 40, para page 2 till page 3. Okay. The present appeal also is on identical facts and concerns the very same premises where a fire accident took place. Therefore, the above decision will squarely apply to the case on hand. Following the above decision, the appeal stands dismissed.
My lord, one indulgence, my lord, is recorded in Sexa 5 is arising out of Excise appeal number 75461. My lord is recorded subject to correction, my lord, 75322. It should be, my lord, 75461.
75461.
61, my lord. Grateful.
Deeply obliged.
Yes. 19. No. 19, you're not.
Write down 19.
21.
My lord, in item number 90, I'm praying for not today, man.
All right.
21. 21, my lord, Mr. Uday Shankar Bhattacharya has been newly engaged, my lord, in the place of.
Now they're on online.
Yes.
My lord, I am on virtual mode.
21.
Not today.
Not today. And not 22. Lord, 22, I am also paying not today, Mr. Day is operating.
23. 24.
24, my lord, Mr. Day is appearing. If I am appearing. 25.
My lord, I am appearing for the respondent, my lord. 25.
Who will appear for?
Mr. Day is appearing, my lord.
Not today.
26.
Not today.
27.
Well, I am paying for not today. 27, I am paying for not today, my lord.
28.
28 and 29.
28, 29.
Okay.
All right, then proceed.
For the mission aspirant number 30, my lord, I am appearing for the appellant. So this was served, my lord. They have received, my lord. There was a delay, my lord. Delay was condoned on the last occasion, my lord. We have filed, may I file of service, my lord? So this is regarding of it's a penny stock, my lord. Reopening was done. If your lordship will kindly come to page number 9, the assessment order, my lord. If your lordship will kindly see, my lord, it was subsequently it was informed that information was received that during financial year 2011-12, it sold BSC Skips Agam Capital Limited having code number such and such, which is a penny stock, as per the report of the report furnished by. It has been seen that for the generation of bogus long-term capital loss, capital gain, the complete transaction was purchase and sale of a penny stock was managed and by the manipulated and bogus transaction of capital loss, and therefore that amount should be bigger. SSC has taken the benefit of such and such. The reopening was done by the assessing officer. Before the CIT appeal, they, my lord, it's an ex parte order, my lord. They took several adjournments, my lord. It's not that, my lord, the opportunity was not given, my lord. They took several adjournments. Sometimes relevant documents were required, but no documents are produced. Therefore, my lord, CIT appeal has, my lord, if your lordship will kindly have a look at the order of CIT appeal, my lord, he has confirmed, my lord. Your lordship will kindly come to page number 18, my lord. Your lordship will kindly see, my lord. During the appelling proceedings, the appellant has only submitted the submissions in the form of statement of facts. After that, neither he has replied the hearing notices nor not submitted any documentary evidences to prove the side. The sufficiency of the adequate opportunity were afforded to the appellant as indicated in the table pages number 2 of the reply whatsoever.
No, this is a case of reopening.
Yes, reopening, yes.
But then you please see the finding recorded by the tribunal.
But tribunal says, it's all recorded in the books of account. Therefore,
Yes. Then,
but the difficulty is, CID,
they have referred to this infinity.
Yes, that I've seen, that I've seen. But the difficulty is, before assessing officer, they have not said anything about CID. Before the CID appeal, also, he did not appear, he took adjournments. His observations were, page 18. I understand, that is there,
And you are having that decision infinity.
Right.
Case number also you don't have. We can open it here.
Just the line.
All right, sir, please come. This appeal filed by the revenue under section 260 cap A of the Income Tax Act 1961, within bracket the act is directed against the order dated September 12, 2023, passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket tribunal in ITA number 400/K1/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law.
Questions about page 4, paragraph 7.
We have heard Mr. Prithvi Dorial and at senior standing counsel appearing for the appellant. The respondent has been served and affidavit of service has been filed, but none appears for the respondent. Though the department would contend that the matter relates to a penny stock, the issue which was decided by the tribunal was whether the reopening of the assessment was valid. The assessee's contention was that the reason for reopening of assessment was that the income of rupees 88,73,135 had escaped assessment, which is generated by the assessee from sale of penny stock. This reason was found to be incorrect since the assessee, found to be factually incorrect. The assessee has not shown any income from long-term capital gains slash business. The reason to believe is bad, and consequently the reopening is illegal. The learned tribunal took note of the decision of this court in CIT versus Infinity Infotech Parks Limited, IT 8060 of 2014. 2014. Thus, we find that on facts, the tribunal was convinced that the reason for reopening was bad in law. Apart from that, the tribunal noted that the alleged transaction has already been recorded in the books of accounts and has been disclosed in the income tax return filed under section 139 within bracket 1 of the Act. And therefore, the very foundation of reopening of the proceedings becomes bad in law. Reference was also made to the decision in the case of CAT versus Jet Airways India Limited 331 ITR 236 and Ranbaxy Laboratories Limited versus CIT 336 ITR 136. Thus, we find there is no question of law, much less substantial question of law arising for consideration in this case. Next.
Number 31.
But I'm appearing in this case. Mr. Rajushi Chatterjee is appearing on the other hand.
I'm appearing for on behalf of Mr. Rajeshri Chatterjee. I'm playing for not today on.
Not today. Next.
32.
My lord, appearing for respondent, my lord.
Yes.
I'm appearing virtually, my lord, respondent.
Yes, sir.
Ballot in this matter, earlier assessment was reopened at the behest of the assessee. After passing of the reassessment order, the PCIT found that there was non-application of mind or non-examination by verification by the assessing officer, and passed direction to pass assessment order afraid. Assessing officer passed the assessment order that was challenged, and that 263 order, my lord, that was not challenged by the assessee. The assessee went in appeal before the tribunal. Tribunal set aside the deleted the addition made by the assessing officer.
But all the subscribers have responded to the 133.6 notice.
My lord, kindly come to the 263 order first, my lord. But there was a specific direction. 263 order is at page 13, my lord.
30
13.
13.
My lord, the directions are at page 18. In view of the special facts and circumstances as well as the judicial decision relied upon, the impugn order under section 148 is therefore set aside. Directions are: examine the genuineness and source of share capital, not on a test check basis, but in respect of each and every shareholder by conducting independent inquiry, not through the SEC. The bank account for the entire period should be examined in the course of verification to find out the money trail of the share capital. Further, the AO should examine the directors as well as examine the circumstances and necessitate the change in directorship. If applicable, he should examine them on oath to verify their credentials as director and reach a logical conclusion regarding the controlling interest. And my lord, kindly come to page 30, my lord. What is the backdrop for giving this direction, my lord?
Before the tribunal,
My lord.
some paper book appears to have been filed. That's what the tribunal records.
My lord, the
Because
tribunal has recorded
the
the 133(6) notices that were issued. These were issued prior to 263 proceedings, my lord.
Have you got a copy of that paper book?
No, my lord. I do not.
My lord, the paper books are with my counsel in the court, my lord. And all the notices, even after the 263 order was issued, thereafter again notices were issued and again it was complied. Kindly see, my lord.
If your counsel can,
Yes, certainly,
then you give copies to Mr. Sharma also.
Yes.
So we'll take it up next week. In the meantime, let the counsel go through these papers. The learned advocate appearing for the respondent SSC has filed a compilation containing the documents which were filed before the learned tribunal, copy of which has been handed over to the learned advocate for the appellate. Based on so and so date.
Second.
Yes, sir. Thank you. Next.
Oblige, my lord.
Item number 33, my lord, in 33,
My
I'm
lord, in
praying
this
not
matter,
to.
I'm praying for not today, my lord. I received the brief day before yesterday, my lord.
Not today.
Item number 34.
Lordship, I am for the respondent, Lordship, I am praying for not today.
All right.
35.
Other side is not here. May I please the
Respondent served.
delay was also condoned on the last occasion.
Who appeared when the delay?
Obhijit Akal Dhudewala and Kush Kanodia, my lord. Not known to us.
All right, not today.
Then both the matters, because for the two different assessment years, my 34, Naki? 35, 36.
Item number 37.
37 is also my application, but I find the other side is also.
All right.
38.
Where both sides are there.
Both sides are in one matter, my lord, 45.
38,
That
39, not today.
Yes.
41.
39, I am appearing, my lord. In this matter, similar questions of law in another matter has been admitted.
Who will appear for the department?
I believe Mr. Mohammed Rai is
appearing. It's not matter. I'm praying for not today.
Then
39 and 47, are arising from the same tribunal's judgment.
Okay, both not today.
Item number 42.
Any matter where, which is your matter?
Item number 45, my lord. I am appearing for the respondent in that matter.
I'm for the assessment. Your Lordship, the question,